We're back on the video record. This begins Media 3 in the deposition of Michael Avenatti. The time is approximately 2:48 p.m. We're going off the video, or we're back on the video record.
Mr. Keathley, before you proceed, allow me to ask you a question. Do you anticipate any more questions that got us to the issue of attorney-client privilege? You anticipate more other than that that you've asked, but you don't have answers for?
I probably will, yes.
Okay. I have read the case. I've only read one case. I think Mr. Baker had a case too, but I didn't get it for some reason. It may be in my notes, but
Your Honor, I know they gave you at least a case citation. I'd like to be able to give that to you as well before you make a ruling.
Well, let's do this.
I'd be happy to brief the issue because it's a significant
well, I know,
issue.
but it doesn't do any good. Mr. Avenatti's here. So why don't you state your position one more time, Mr. Keathley, now that I've read the case that you have cited me to?
My understanding is that where there are multiple law firms representing clients and there is litigation between the clients and one of the attorneys, the communications between the client and the other attorneys that represented them is not protected under the attorney-client privilege, and therefore the discussions, in order to avoid I believe it was collusion between the remaining attorneys and the clients, is open for discovery, and the privilege does not apply.
Thank you. Mr. Baker,
Yeah.
You can address that case that you've read, and you can tell me about the one that I haven't read. I have no difficulty with
Okay. Anton versus Superior Court had two clients suing a single lawyer. One client sued. That's not remotely the issue here. They are trying to make that case one where a lawyer can sue a client and waive the privilege between that client and other lawyers. That's not what Anton says. Anton says when one client sues a lawyer, it's completely different because the lawyer institutes an action, he waives the client's privilege with other lawyers. It's absurd. And in the legal malpractice environment, this is well-settled law. And the case I quoted you was Kroll and Track versus Paris and Paris, 72, Calap 4th, 1537. And it comes up all the time when there's a...
What was the page again?
1537 is the initial page. It comes up all the time when clients and a single lawyer are in a dispute and they try to waive the privilege and bring in a second lawyer. And they say you can't do that. The client doesn't give up his privilege with the second lawyer because there's an action between this lawyer. And this action is even more far-fetched because Mr. Stoll is the one that brought the clients into the case. So there is no waiver. A lawyer can't go to a client and say, your privilege is waived with subsequent concurrent predecessor lawyers.
Mr. Keathley?
Well, the clients brought Mr. Stoll into the case, and the fact that their case was thrown out on a demur without leave to amend doesn't cure the fact that they're the ones that initiated an action against Mr. Stoll for malpractice, which is tied to this case. Even though that action's gone, the underlying issues regarding that still exist. And what we've got here is allegations of what Mr. Stoll said or did, and they're attempting to use the shield of the attorney-client privilege as between the remaining attorneys, who are defendants in this case, to shield themselves. Of course, I don't know how they're going to prove their elements without having their clients testify, but I don't think the privilege, according to the case that we cited you, applies.
Last call, Mr. Baker. Anything?
You can't have a dispute between a single lawyer and a single client waive the privilege. Here's what the Kroll case says. Kroll and Tract, T-R-A-C-T, Linda, argues that the fear of revealing client confidences should not bar its cross-complaint. It claims the commencement of the malpractice...
Sorry, you have to slow down.
I'm sorry.
Should not bar.
Its cross-complaint. It claims the commencement of the malpractice action as to one attorney should operate as a waiver of the privilege as to both attorneys regarding communications relevant to the joint representation. But that is not the law. The client is the holder of the attorney-client privilege, and San Jose Crane expressly preserved the privilege as to Paris and Paris by choosing not to sue it for malpractice. That's the law.
Okay, well, we're all predictors of where things are going to go, and we don't have all the time in the world. So have to make a decision. The decision is that I find that there is a waiver. I couldn't find the specific language where things were waived yesterday. I looked at my brief, but I believe that this case prevails. So I'm going to overrule the objection. You get to do what you want to do. I can do this. You asked for briefing on it. I noticed that Mr. Keathley actually briefed this.
I haven't seen that.
I know, but he didn't give it to me or to you, okay? But he actually briefed it. It's here. It's dated yesterday. So that behooves me to give you the same opportunity to brief it. But on the other hand, we are here, and we are basically, unless you want to use Friday to go on with Mr. Avenatti, we're basically done. So
okay, I'd like to see his brief.
Yeah,
I don't know if it was
yeah,
mailed
but
to...
I didn't give it to you because he didn't.
I thought I brought copies of it for today.
So I'll give it to you by all means, because I made copies of it. Actually, it's here. I made copies of it, and I'll let you have another run at it. We get together tomorrow anyway.
Okay.
But you get to do whatever you need to do with regard to your client. But for the time being, I have to say that your objection's overruled, and we just have to go where we're going to go.
I hear you. I mean, I feel a little bit running up a sand dune right now. I didn't see the brief. I'm trying to...
Well, the
argue.
brief doesn't say. I just read the case.
But I'd like
It's
to.
the case.
I'd like to look at the brief and respond. And for now,
Of
I'm going to
course.
stand on the objection.
I'm giving it to you.
Okay.
You can. We're going to be together tomorrow at 3, so I can. Trying to think of.
I'll try to.
I'll read it. You get it here. I'll read it before we get started.
I'll try to get something together.
And I'll read. You give me the case citation, so
Okay.
I'll read it
Very well.
tonight. But you can still brief it. I don't have any difficulty with you making a good record, and then we just have to go where we have to go.
Thank you, Your Honor.
Okay. So you may continue, Mr. Keathley.
For purposes of clarification, Phil, are you standing by the objections and your instructions not to answer all of those questions? And is my understanding, even though the judge has made a ruling, you're not going to answer those questions?
Correct.
Then I will save the court reporter having to go out and look at every one of those
Absolutely.
questions and objections.
Just so the record is clear, it was a report and recommendation by Judge Polis, not an order of the Superior Court judge at this point.
I understand.
Well, of course. It's just a discovery ruling. That's what you invited me to do. It hasn't become an order of the court until it gets before the court, and so there's certain protection involved in that. Mr. Keathley, you may continue.
And just as a further clarification, the order comes down, then that will require us to renotice and retake Mr. Avenatti's deposition to answers to those questions. So
It is what it is.
Got
It's not a creation of mine.
understand.
Well,
He doesn't get an additional time beyond the 7 hours. I mean, there's no provision for that in the code, so it's his time.
Yes, there is.
Sure.
Under what provision?
I have ordered many times the depositions to go for 2 and 3 days. Well, we didn't go to the same class on Deposition 101.
Well, why is it that Mr. Stoll's deposition is limited to 7 hours and mine is not?
I'm not the boss, Michael.
All right,
You
we'll
guys
we'll
get to do
discuss-
what you get to
We'll
do.
discuss this at a later time.
And remind me to tell you the story of the attorney who stood in front of me and said, "But Your Honor, I have a constitutional right to take a deposition." And I asked him, I had my bailiff take him over a copy of the Constitution, and in front of about 125 people in law and motion, I said, "You know, that's something I haven't seen. Would you want to
California
would
Constitution.
you want to be sure to find it for me?" So, no, I'm just joking. I'm
All
just
right.
pulling your leg.
We're good.
So, we're good. Just you
Okay.
get to do what you get to do.
Let's get going. Mr. Avenatti, in terms of percentages, how much of the percentage of the work in the Fleur case did your firm do?
Over 90%.
With respect to Mr. Panish and his firm, did they prepare any of the written discovery requests?
I believe they participated in the drafting of some of the discovery and motion practice in the case, among other things that they did.
In the written discovery, how many of the written discovery requests did the Panish firm participate in?
I can't answer that question as I sit here today without being shown some documents.
And Mr. Panish's firm assisted with the drafting and filing of the original complaint, is that correct?
Yes.
And they assisted and participated in the drafting of the first amended complaint?
I believe so.
And do you have a number of hours that the Panish firm was involved in drafting the original complaint?
Not without looking at other documents.
Do you have the number of hours that the Panish firm was involved in drafting the first amended complaint?
Same answer.
Did you send to Mr. Panish's firm motions that you had prepared?
Yes.
Was that the purpose? Was that the purpose of him or his firm reviewing those motions?
I don't understand the question.
Okay. Why did you
didn't
send?
give me a purpose.
Why did you send motions that you had prepared to Mr. Panish's firm?
For a number of reasons, including that I wanted him to be aware of what was going on in the case. I wanted to strategize with him relating to his thoughts on the motions. I wanted to get his input on the motions. Those are some of the reasons that readily come to mind.
When you sent the motions to Mr. Panish's firm for his review, did you ask him to contact you regarding his advice and strategy and input?
Generally, yes, but without having documents in front of me, I can't answer as to specific motions. If you have something you'd like to ask me about, I'd be sure to answer it. Or if you have the docket from the case, that may refresh my recollection.
And what about with respect to motions that were brought by the defense in the Fleur case? Did you send those to Mr. Panish?
Well, I believe the defense would have served those on Mr. Panish.
Did you ask specifically Mr. Panish to review those defense motions and get his strategies and input regarding those motions?
From time to time, yes.
And were these requests of Mr. Panish, were they in writing?
I believe some of them were. Other requests were oral.
And with respect to the defense motions, likewise, some were in writing and some were oral?
That's my best recollection.
You also sent discovery requests to Mr. Panish's office.
I believe Mr. Panish's office and Mr. Stoll's office were served with all of the discovery requests.
Okay. And did you have conversations with, did you ask Mr. Panish to review the discovery requests which were sent to him for his input and strategic analysis?
I'm not going to answer that question based on the attorney-client privilege.
Was the only reason why you sent Mr. Panish the discovery requests was because he was co-counsel and on the proof of service?
Why I sent those documents to Mr. Panish would be privileged under either the attorney-client privilege and or the work product doctrine. I'm not going to answer that question, and I'm going to assert a standing objection on behalf of myself and Mr. Parrish and Mr. Fitzgibbons to any questions relating to communications that I had with Brian Panish during the pendency of the case and during the pendency of the FLIR matter, as well as up through today relating to the FLIR matter based on the attorney-client privilege and work product doctrine. My failure to assert that objection to each and every question as asked should not be deemed and will not be deemed to be a waiver of any such position. I'm also asserting the same objections as relates to communications that I may have had with Mr. Parrish or Mr. Fitzgibbons in connection with the underlying FLIR matter to which Mr. Stoll was not present for, either in writing or orally. And that includes during the pendency of the FLIR matter as well as thereafter up and through today. Same position as it relates to lack of a waiver. And that's made on behalf of myself as well as Mr. Parrish and Mr. Fitzgibbons.
Did Mr. Panish ever tell you that he had any dissatisfaction with any of the services Mr. Stoll was providing with respect to the FLIR matter?
I'm going to refuse to answer. Same position.
How many depositions did Mr. Panish attend?
I believe Mr. Panish attended approximately half of the depositions in the case.
So 4 of the depositions?
I don't recall exactly how many depositions there were in the case as I sit here today. My recollection is there was about somewhere in the neighborhood of 8 to 10. I don't know how many days those depositions lasted. I have a recollection of Mr. Panish playing a substantive role at a number of those depositions, unlike Mr. Stoll. I have a recollection of Mr. Panish traveling to Boston with me in connection with that deposition, which was a critically important deposition in the case. I have a recollection of Mr. Panish traveling to Portland, Oregon in connection with that deposition, which is another critically important deposition in the case. And I have a recollection of Mr. Panish being involved in other days of deposition in the case. Mr. Panish and I communicated on a fairly regular basis in connection with the case, and suffice it to say that Mr. Panish and his firm's contributions to this case were significantly, substantially, extraordinarily greater than any contribution by Bob Stoll or his firm.
Wow. Okay. How many depositions did Mr. Panish attend in which he was the attorney that was actually asking the questions?
I don't believe that Mr. Panish directly asked any of the questions. I do recall that, for instance, at the Bob Lewis deposition in Boston, that Mr. Panish sat to my immediate left and provided significant advice during the pendency of that deposition. Mr. Lewis was the CEO of FLIR at the time of that deposition.
Did you ask Mr. Stoll to attend any of these depositions?
You already asked me that, and I'll give you the same answer I gave you before. Yes, I asked him repeatedly to attend depositions, and he only showed up at one and worked on other case files. That being Mr. Johnson's in Santa Barbara.
Mr. Panish attend any of the hearings on any of the motions?
Yes.
How many hearings did he attend?
If you have a docket, I'd be able to refresh my recollection as to how many hearings he attended, but I have a recollection of him being at various hearings in connection with the case. I know for a fact, for instance, that he was at the anti-SLAPP hearing. He provided substantial input in connection with that hearing. He and Mr. Sims and I actually drove to Santa Barbara together and drove back from that hearing, during which we discussed the strategy for that hearing and how it was going to be argued and what positions we were going to take and a whole host of other issues in connection with the anti-SLAPP motion.
And Mr. Stoll could not be a part of that meeting you had while you were driving up there because he lives in Santa Barbara, correct?
I don't know where Mr. Stoll claims to live. I still haven't been able to figure that one out.
So the answer to my question is that he was not part of that meeting as you were driving up. Is that correct?
I don't understand the question. Are you asking me, was Mr. Stoll in the car?
Yeah.
The answer to that question is no.
Okay. Did you invite him to drive up with you?
I don't recall inviting Mr. Stoll to drive up with us, but I do recall meeting Mr. Stoll before the hearing when we arrived, during which it became apparent to me that he was not familiar with the issues that were going to be argued that morning.
And did you tell that to Mr. Panish?
I'm not going to get into what I told Mr. Panish based on the attorney-client privilege and work product doctrine, as I previously stated.
And according to your testimony, the Panish firm only did approximately 10% of the work with respect to the floor matter, correct?
No, I don't agree with that. I think when you ask me the percentage of the work, if you're talking about the percentage of the hours, that may be true, but there's also value relating to strategic planning, decision-making, etc. So it's not just an hours determination, but it's also what value you bring to the case beyond that, relating to strategic advice and the like. And so I don't believe that the Panish firm and Mr. Panish, that their involvement, even though they may have done approximately 10% of the hours in the case, can be adequately judged merely by that number.
But with respect to the 10% of the hours of work, it ended up in Mr. Panish receiving $5.26 million, correct?
I'm going to stand on my prior answer in connection with that, relating to the distribution of the monies being at the direction of the client.
You, in fact, asked the clients to pay Mr. Panish $5.26 million, I'm sorry, $5.25 million for his 10% doing the work. Is that correct?
Now, there's no question that whatever I ask the clients to do, sir, is absolutely privileged. So I'm going to stand on the objection. You already asked me about that earlier. I'm not waiving that objection. You also sought to ask me about an attorney-client privilege document earlier, and I'm again...
Look, why don't we do it this way? Either I'm going to send Mr. Baker home and you can play both roles, or Mr. Baker gets to make the objections. Okay, Mr. Baker? I think it'll be a much cleaner record if you make the objections.
Sure.
I know what the objection is, and I wrote it down every
Okay.
time. So, go ahead, Mr. Keathley.
Thank you. At any time during the floor matter, did you ask Mr. Stoll or his firm to pay any of the costs?
Yes.
How many times?
A number of times.
Were these requests in writing?
I don't recall if any of them were in writing or not as I sit here today.
Did Mr. Stoll's firm pay any of the costs?
Well, evidently, according to Mr. Stoll, they paid approximately $5,000. I don't know if that's accurate or not.
I'm going to show you a document which will mark as Exhibit 14. It's the Notice of Association of Counsel.
Thank you.
You're familiar with this document, correct?
Yes, sir.
And if you turn to the second page, is that the signature that was crafted by your secretary?
I instructed someone in my office to sign this document and file it on my behalf.
But that's Miss is it Mosby?
I'm sorry?
Is that Mosby?
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 I don't know if it's her signature or someone else in my office's signature. But it was signed at my direction.
And this is when you first associated in in the floor action, correct?
No,
It's not?
no. We were involved in the case from the very beginning stages, as I've testified. This was the first instance in which we actually filed a formal notice of appearance in the FLIR matter.
And you prepared a first amended cross complaint, is that correct?
We participated in the drafting of that document. I believe my office took the lead in preparing it.
I'll show you a document which we'll mark as Exhibit 15. It is the first amended complaint.
I have the document and I'm familiar with it.
Thank you.
Did you seek the input from Mr. Stoll's office or Mr. Panish's office with respect to the drafting of the amended complaint?
Yes.
Who in your office actually was involved in the drafting of the amended complaint?
Well, I was certainly involved. I don't know, without more information before me, who else was involved. I would speculate that Mr. Sims may have been involved.
We also show you another document which we'll mark as Exhibit 16. It's an email dated November 16, 2009.
Do you have a bait stamp copy?
Familiar with this document?
Before I answer that question, do you have a bait stamp copy?
It's my deposition. I get to answer the questions, so
You get to ask.
I get to ask. I'm not answering it.
Your
So-
question is, has he seen this
Is he
document?
familiar with it?
In answer to that question, no, I'm not familiar with the document.
Okay. Who is Junie? Is it Regner?
Judy Renier, she works in my office.
Okay. Is she a secretary or?
She is a paralegal and an office manager. And this refreshes my recollection that she would have been one of the people that was involved in the drafting of the First Amendment complaint.
Did you direct her to have the First Amendment complaint sent to Mr. Stoll and Mr. Panish for review?
I don't recall.
If you look where it says gentlemen, and then there's a paragraph underneath there, do you believe that the information contained in that paragraph is accurate?
Gentlemen, please review the draft of the First Amendment complaint attached here too. This document needs to be filed on Friday, November 20th, 2009. So we request that you have all comments to us on or before noon on November 19th, 2009. Thank you. And then it has her contact information. I believe that's accurate. And this also refreshes my recollection that, in fact, Mr. Sims was involved in the drafting of the First Amendment complaint because he's copied on the email.
Did you receive any input by Mr. Stoll with respect to the First Amendment complaint?
As I sit here today, I do not recall, based on Mr. Stoll's testimony yesterday, he testified that he made some minor corrections to it. I believe that was his testimony. I don't know if that's accurate or not as I sit here today without looking at other documents.
Did you receive any input from Mr. Panish or his firm with respect to the First Amendment complaint?
I don't recall.
Let me show you a document which we'll mark as Exhibit 17. It's a note dated November 14th, 2009 from Mr. Stoll to Michael. Recall receiving this document before?
Well, this document doesn't look complete to me.
That wasn't my question. My question was, have you seen this document before?
I may have. I don't have a recollection of it, but the document's not complete.
And did you have any conversations with Mr. Stoll on or around November 14th, 2009 about sending him a copy of the First Amendment complaint?
Not that I recall as I sit here today.
Now, between November 19th, 2009, when the First Amendment complaint needed to be filed, and May 13th, 2011. Did you ever tell Mr. Stoll that you were not happy with anything he was doing with respect to the floor case?
Absolutely.
Did you tell Mr. Stoll you were not happy with what he was doing in the floor case in writing?
As I sit here today, I don't recall whether those comments were in writing or not.
When was the first time during that time period, from November 19th, 2009 through May 13th of 2011, that you told Mr. Stoll you were not happy with his performance in the floor case?
I don't recall the very first time that I voiced those concerns, but I voiced them to Mr. Stoll repeatedly.
Well, you may not recall the very first time, but you call what it was that you first told Mr. Stoll you were not happy with.
I believe the first criticism that I made to Bob Stoll was that he was not upholding his end of the bargain. They were not doing 35% of the work. He was ill-prepared when he did show up, which was rare. I was critical of his conduct at the deposition of Bob Johnson. I thought it was outrageous that he would show up for that deposition, which I believe was the first deposition in the case, looking as if he had just come off the tennis court with a stack of personal injury files, sitting at the end of the conference room table, not paying attention to the deposition, working on his other case files. The clients were very upset about it. My recollection is that Bill Parrish asked Bob Stoll, basically, what are you doing? I don't know that that was the first instance, but it was close to one of the first instances where I voiced my displeasure to Mr. Stoll regarding his ill-preparedness, lack of contribution to the case, and general attitudes towards the case. There were a number of instances where I voiced my concerns, including at both mediations.
We'll get to those. And so this first criticism, if I could use that term, that was in May of 2011?
No.
When was Mr. Johnson's deposition taken?
My recollection is the case settled in May of 2011.
I understand that. When was Mr. Johnson's deposition taken?
I don't have a recollection. If you have the deposition transcript in front of you, or if you could refresh my recollection, I'd be happy to answer it.
You don't recall in the, let me do it this way. The remaining part of 2009, did you voice any criticisms to Mr. Stoll about what he was doing in the Fleur case?
I don't, what do you mean remaining portion of 2009?
November of 2009 is when the first amended complaint was filed, correct? November 19th?
Yes, November 20th, 2009.
Okay. And so from that point in time until the end of 2009, did you have any criticisms which you told Mr. Stoll about his performance?
I don't recall if any of my criticisms voiced to Mr. Stoll took place during that time period.
Okay. What about 2010? Did you voice any criticisms about what Mr. Stoll was doing or not doing to him in 2010?
Yes, repeatedly.
So how many times in 2010 did you voice criticisms to Mr. Stoll?
5 to 10. And I want to be clear with my testimony in that it's difficult for me to place certain things in time without having a copy of the docket in front of me from the case.
And did your criticism start in the first quarter, second quarter, third quarter, fourth quarter?
Sir, my criticisms may have started in late 2009, as I've testified. I don't know when my very first criticism of Mr. Stoll was. I recall one of the criticisms taking place at Mr. Johnson's deposition, and I don't know when that deposition took place. I think that was in the first half of my criticisms of Mr. Stoll. That's my best recollection. But if you could represent to me when Mr. Johnson's deposition took place, that might help anchor the timing for me.
After Mr. Johnson's deposition, did you tell your clients that they should terminate Mr. Stoll's firm?
I'm going to object. That's a privileged communication. Don't answer that.
After Mr. Johnson's deposition, why wasn't Mr. Stoll's firm terminated?
Same objection. That goes to work product. It's speculative. It could lead to attorney-client privilege. Don't answer that.
With respect to the criticisms you had of Mr. Stoll prior to the Johnson deposition, why was Mr. Stoll not terminated?
Same objection, same instruction.
I'll follow the instruction, but I'll also add that, again, I don't know whether there were criticisms before Mr. Johnson's deposition or not. I'd like the date of Mr. Johnson's deposition. If you could provide that to me or show me the transcript or something, that would be helpful.
After Mr. Johnson's deposition, did you have any further criticisms of Mr. Stoll with respect to the Fleur matter?
Yes.
Okay. What criticisms did you have after Mr. Johnson's deposition?
The criticisms that I've already testified to, that Mr. Stoll hardly ever showed up, did not participate in the conference calls. When he did show up, articulated a clear misunderstanding of the legal issues in the case, was ill-prepared, his firm did not do their share of the work, did not do close to 35% of the work. Even if they did perform 300 hours, as Mr. Stoll has now testified to, which it's our position they did not, by the way, perform anything close to 300 hours, that was not nearly 35% of the work, that the quality of the limited input and work and strategic advice that Mr. Stoll and his firm did provide, which was extremely limited, was absolutely useless to the process, and actually obstructed the process and devalued the case in some ways.
Did this all occur prior to the second mediation?
No, some of it continued and bled over into the second mediation. And I guess I would also add that Mr. Stoll's advice to the clients to commit tax fraud during the second mediation was also, in my view, highly unethical and inappropriate and unprofessional.
Of course. Tell me why, prior to the first mediation, Mr. Stoll's firm was not terminated.
That's the same objection, same instructions I made to the last inquiry in this area.
And I'm going to follow that instruction, but I will add that my firm and me were not responsible for determining when or if Mr. Stoll or his firm was terminated at any point in time. That wasn't up to us. That wasn't our decision to make because we weren't the clients. Mr. Parrish and Mr. Fitzgibbons were the clients. They were the ones that got to determine which attorneys were permitted to work on their case and which attorneys were not permitted to work on their case, and which attorneys were terminated and which weren't. That was their decision. That wasn't up to us.
Did you in any way attempt to influence Mr. Parrish and Mr. Fitzgibbons prior to the first mediation to terminate Mr. Stoll's firm?
That would directly implicate the attorney-client privilege. Do not answer that.
I'm going to follow the advice of my counsel.
And not add anything?
No.
Did you attempt?
My judgment's getting better, Your Honor.
Did you attempt to influence Mr. Parrish or Mr. Fitzgibbons between May 13th and May 31st of 2011 to terminate Mr. Stoll?
Same objection, same instruction.
I'm going to follow the advice of my counsel.
I'll show you a document which we'll mark as Exhibit 19? 18? Yes, it is. You're familiar with this document, correct?
I have seen the document before, yes.
Okay. Did your firm draft this document?
Same objection, same instruction.
I'm going to follow the advice of counsel.
Did you counsel Mr. Fitzgibbons or Mr. Parrish to send this document to Mr. Stoll?
Same objection, same instruction.
I'm going to follow the advice of counsel.
Did you discuss with Mr. Fitzgibbons and Mr. Parrish terminating the Stoll firm?
Called for privileged information, same instruction.
I'm going to follow the advice of counsel and refuse to answer based on the attorney-client privilege and work product doctrine.
Did you discuss with Mr. Fitzgibbons and Mr. Parrish them emailing Exhibit 18 on May 31st, 2011 to Mr. Stoll?
Objection, privileged, work product. Do not answer that.
I'm going to follow the instruction of counsel and refuse to answer on the basis previously stated.
Can you tell me the reason why you waited till they waited till May 30th, 2011 in order to send Exhibit 18 to Mr. Stoll?
Same objection, same instruction. Do not answer that.
I'm going to follow the instruction of counsel and refuse to answer based on the same privileges.
Hadn't your firm received a wire of $39 million on May 30th, 2011?
No.
Was it on May 31st of 2011?
I believe that's accurate.
Let's talk about the first mediation. Who attended that mediation on behalf of Mr. Parrish and Mr. Fitzgibbons?
Bob Stoll, myself, and Scott Sims.
Was Mr. Panish there?
I do not believe Mr. Panish was at the first mediation.
Did you ask him to attend?
That would be a privileged communication between Mr. Panish and Mr. Avenatti. Don't answer that unless it was in the presence of Mr. Stoll.
I'm going to follow the instruction of counsel.
Did you have any criticisms of Mr. Stoll's participation in the mediation, the first mediation?
Yes.
What were they?
Mr. Stoll showed a fundamental misunderstanding of what the case was about, the legal issues in the case, a fundamental misunderstanding of how to handle a business litigation mediation, a fundamental misunderstanding of the client's positions in the case, and I thought his participation was obstructionist and generally useless and provided no value to the case or to the clients.
Did you tell that to the clients at the mediation?
That's completely privileged work product. Don't answer that.
Did you tell that to the clients in the mediation in front of Mr. Stoll?
You can answer that.
I did not tell that to the clients at the mediation in front of Mr. Stoll.
Why not?
That goes to work product. Don't answer that.
No, it doesn't. It's a factual reason why he didn't. I'm entitled to know
It
it.
goes to his thoughts and impressions. Don't answer that.
I'm going to follow the instruction of counsel.
Your Honor.
I wasn't tracking, because did I hear work product? Is that
Yes.
is that what you said? Yeah, I'm gonna put it in with the same, I don't think it makes a difference, so it's the same ruling, and so I'll note it, objection with advice. You may continue, Mr. Keathley.
Thank you. Did you express your criticisms to Mr. Stoll at the mediation?
Yes, I believe I was rather vocal to Mr. Stoll relating to my thoughts as to his conduct at the mediation, the first mediation.
That's surprising.
Your Honor, you don't need
I'm sorry,
comments.
I actually couldn't hear you, Mr. Keathley.
Can I have that read back?
It was not surprising, was his comments.
No, it was surprising.
Oh.
Oh, okay. You may continue,
Thank you.
gentlemen.
And what was Mr. Stoll's response, if anything, to your rather vocal criticism of him at the mediation?
I would describe it as recognizing that he didn't know what he was talking about.
What did he say?
I don't recall the exact words that he said, but he acknowledged that he generally did not know what he was talking about. Mr. Stoll approached this mediation like it was a personal injury case, and it wasn't a personal injury case. He had communications with the mediator without my consent, without Mr. Sims' consent, without the client's consent, and his conduct created, in my view, a very uncomfortable situation from the get-go in the mediation relating to our communications with the mediator, to the point where I took charge and made it clear that no one was going to be communicating any positions of settlement to the mediator until there was agreement in the room amongst us as to how to proceed.
Do you know the number of business litigation mediations Mr. Stoll have been involved in prior to this first mediation?
Just, do you know the number?
No, I don't know the number.
Did you ask him?
No, I didn't feel like I needed to.
Did you ask Mr. Panish how many business litigation mediations Mr. Stoll had been involved in?
That would be the exact same, unless you asked him in front of Mr. Stoll. It's the same instruction. Do not answer that.
I'm going to follow the advice of counsel.
Did you send Mr. Stoll a letter or an email that encapsulated your criticisms of his attendance at the first mediation?
Not that I recall.
Did you suggest to Mr.
I think I
Parrish?
had made it pretty clear at the first mediation as to my thoughts as to what had transpired. As a general proposition, Mr. Keathley, when I'm critical about something, generally people don't come away from that discussion wondering how I really feel about it. It's either a positive or negative, depending on your viewpoint, I guess. But I thought I was pretty clear in the mediation as to what had transpired and how upset I was.
And did you suggest to Mr. Stoll at that time that maybe he should just substitute out?
No,
Why not?
because I didn't think it was my place to do that.
Did you suggest to the clients that they should have Mr. Stoll substitute out?
Same objection, same instruction.
Did you tell the clients about your criticisms of Mr. Stoll after the first mediation?
Same objection, same instruction. Do not
At-
answer that.
After the first mediation or at the mediation?
After the first mediation.
No, I'm going to follow the instruction of counsel.
What about at the mediation in front of Mr. Stoll?
Yes, the clients witnessed what transpired in the first mediation. They were there.
And they heard you being rather vocal with Mr. Stoll at the mediation?
My recollection is, yes, that they were in the room with us, and my recollection is that Mr. Sims was also in the room.
And they didn't tell you we want to get rid of Mr. Stoll?
That's same objection, same instruction. Do not answer that.
What transpired at that first mediation, if anything, with respect to the resolution of the Fleur matter?
Well, nothing transpired relating to the resolution. There was no offer put on the table, as I recall, and it was a fairly short-lived mediation.
What about the second mediation? What was the time frame between the two mediations?
I don't recall the date of the first mediation without looking at a document to refresh my recollection. The second mediation occurred in May of 2011, and to be clear, the second, we've been calling it a mediation, but it was actually a mandatory settlement conference that then, in my view at least, continued as a mandatory settlement conference. I guess you could say it continued as a mediation, I suppose, but it started off as a mandatory settlement conference on that morning. And I'm trying to recall if the first mediation also was court-ordered, and I think that it was. It may have been a mandatory settlement conference as well, but I recall that my best recollection is the parties did not voluntarily choose Judge Reiner, Eleanor Reiner, who was a retired judge from New Jersey, who Mr. Stoll told me he had no experience with.
Okay. between the first mediation and the second mediation, did you have any communications with Mr. Stoll regarding the second mediation?
In anticipation of the second
Just
mediation?
any communications?
I had many communications with Mr. Stoll between the first and the second mediation on a host of topics, including the second mediation.
Okay. How many communications did you have with Mr. Stoll between the first mediation and the second mediation?
Well, I don't recall when the first mediation was, and I don't have a docket in front of me from the case to help refresh my recollection as to the motion practice, et cetera. So I think the short answer is I can't give you a specific number or estimate, but there were a number of communications.
And what did these communications entail?
Communications about the status of the case. Mr. Stoll was copied on numerous documents that were filed in connection with the case. There were communications about Mr. Stoll not doing his load of the work, or his firm's share of the work, or his firm not doing their share of the work. There were communications regarding various depositions in the case, various discovery issues in the case, various motions that had been filed in the case, hearings that were taking place in the case, a whole host of issues that one might expect in a very complex, contentious business litigation matter involving tens of millions of dollars.
I represent to you that the first mediation occurred in July of 2010. All of these things that you have just, the whole host of items, did they occur between July of 2010 and May of 2011?
I don't recall if they took place during that time period. What I do recall is they took place during the years 2010 and 2011 until the settlement of the case against Fleer.
And did you relate all of these, did you do the same sort of communications with respect to Mr. Panish?
I don't understand the question. If you're asking him about his communications with Mr. Panish, it would be the same instruction, same objection, but I may have misunderstood what your question
No,
was.
I'm asking him with respect to the status of the case, the documents, depositions, motions, hearings, and a whole host of things one might deal in a complex business litigation. Did he also send that in or communicate with Mr. Panish regarding those?
I think that would be a privileged communication.
Your Honor, court's indulgence for 1 minute. Sure.
He corrected me. Maybe it's late. If Mr. Stoll was present, you can answer that area.
There were certain communications that took place with Mr. Stoll and Mr. Panish both present, or I was communicating with them at the same time. So we have no objection to.
If Stoll's present, you can answer
All right.
that inquiry.
Okay.
Actually, it's a different category of communication. I don't think it has anything to do with the attorney-client privilege. In other words, the question was, the first question was, did he communicate with Mr. Stoll about, not about his criticism, but about all of the things that were going on in the meantime? And then he asked the same question about Mr. Panish. So I don't see that even relates to the attorney-client privilege.
Well, I don't want there to be a waiver of the work product privilege.
I appreciate that.
And if
He can still
All right, go
do
ahead.
what he wants to do, but I'm just telling you,
I was the
I
bottom-
didn't see.
I was the bottom of my law school class, Your Honor. So,
Well,
Michael, go ahead.
don't feel bad. I was in the top 7/8 of.
Okay, go ahead.
Various communication. My firm had various communications with Mr. Panish that Mr. Stoll was present on by email or calls and the like relating to the status of the case, etc. There were other communications that my firm had with Mr. Panish, and we're not going to answer questions based on those communications or about those communications based on the attorney-client privilege and the work product doctrine. But as a general proposition, my office informed Mr. Panish and Mr. Stoll and his firm about the status of the case on a regular basis together, including what depositions were coming up, discovery that had been propounded and that had been received, motion practice, and the like. This was a very active file, a very busy file, and it took an enormous amount of time from my law firm, and certainly something significantly greater than 300 hours reading the Daily Journal.
Okay, thank you. Did you have conversations or communications with Mr. Stoll regarding the second mediation in May of 2011?
Yes.
And how many communications did you have with Mr. Stoll regarding the May mediation?
A few.
And were these communications by telephone, email, letter, fax? How?
I don't recall any communications by letter or fax. I recall that we drafted the mediation brief that was used in the second mediation/settlement conference. I recall we also did that in the first, or for the first mediation settlement conference. I recall that we provided a copy of that to Mr. Stoll. I believe that I communicated with Mr. Stoll before the settlement conference and the mediation, and I certainly communicated with Mr. Stoll during the mediation and the settlement conference. We're talking about the second one in May of 2011.
Okay. Did you send the mediation brief for the first mediation to Mr. Stoll for his comments, review, thoughts, or had you already completed your mediation brief?
I don't recall.
And what about with respect to the second mediation brief? Did you send it to Mr. Stoll for his views, thoughts, or input?
I believe that we did.
And did Mr. Stoll provide his views, input, review of the second mediation brief?
Not that I recall.
Jim, I'm going to trade defense lawyers, plaintiff's lawyers. But I don't want to slow down the process. Scott, let's trade seats.
Yeah, go ahead.
Did you have any telephone conversations with Mr. Stoll prior to the second mediation in May of 2011 regarding it?
I believe we may have had one or two.
What was the substance of those one or two telephone conversations?
I don't recall.
Did you have any communications with Mr. Stoll prior to the May 11 mediation to the effect that you better be prepared, you better understand this, you better be able to contribute to this mediation?
No, I don't recall telling Mr. Stoll that.
Did you invite Mr. Panish to the second mediation?
Objection, calls for attorney-client work product information and instruct the witness not to answer. I'm not sure that it does. He's a lawyer on the case. But you can stand by the objection if you want.
I'm going to stand by that objection as well as the attorney-client privilege and not answer the question.
Did Mr. Panish attend the second mediation?
No, sir. He was available by phone.
Where was Mr. Panish?
I don't know. But I do recall that he was regularly available by phone. I called him a number of times that day.
And how long did this second mediation last?
We arrived for the mandatory settlement conference. I believe that it was a cattle call, if you will, as many of them are. I believe that was at about 9 a.m. We met with Judge Reiner. Approximately 2 or 3 hours later, we relocated to a private office in Santa Barbara. The settlement conference continued and lasted well into the evening.
Do you recall having any conversations with Mr. Panish during the second mediation?
Yes.
What about?
Rejection, instruction not to answer, privilege, work product.
The mediation privilege has been blown a long time ago. It was done yesterday.
Attorney-client and work product, instruct the witness not to answer.
I'm going to follow the instruction.
Okay, it's overruled, but you do what you think's best. I don't think it's in the same ballpark as what you were talking about before, but
Did you have any conversations with Mr. Panish on a speakerphone in which Mr. Stoll was present?
I believe there may have been one such conversation during the mediation on a speakerphone where Mr. Stoll was present.
And what did that conversation entail?
That conversation related to our position in the case, the defense position in the case relating to dollar levels, and the delta or difference between the two positions, and whether the plaintiffs should, or what move the plaintiff should make next. That's what I recall.
And what did Mr. Panish have to say?
I don't recall exactly what Mr. Panish had to say, but I recall him being supportive of my position.
Did you take any notes down with respect to this conversation?
Not that I can recall. No.
Did you have conversations with Mr. Stoll during the second mediation, after
Yes.
mediation?
Yes, many.
What conversations did you have, if you can best recall?
Well, I don't know that I can recall everything that was said during the mediation, but I do recall that contrary to Mr. Stoll's testimony, Mr. Stoll was desperate to settle the case that day. I most certainly was not desperate to settle the case that day. In fact, there was no expectation that the case would settle that day. I can recall Mr. Stoll stating that if we could get $10 million for the case, that would be a home run, to which I responded that that was outrageous, that the case was worth far more than $10 million, and there was no way, quote, no way in hell, close quote, that the clients were ever going to accept $10 million for settlement of the case. And my recollection is that one or both of the clients were privy to those discussions that I had with Mr. Stoll. I also recall being very critical of Mr. Stoll's position or recommendations throughout the mediation as to strategic moves that should be made. And then, of course, I was also very critical when Mr. Stoll advised the clients that they should merely not report the proceeds of the settlement and take the audit risk, as most of his clients had done previously in personal injury actions. That came in response to a question or questions by the clients as to how much they were actually going to net from the proceeds, because the clients voiced to Mr. Stoll and I a concern as we began to get closer relating to settlement. They voiced a concern about what their actual net amount of money was going to be after the deduction of taxes by both of them. And I have a recollection of Mr. Fitzgibbons being particularly concerned about that issue, and they were inquiring about taxes and what amount of taxes would be taken out, and that's when Mr. Stoll gave them the advice that he did in my presence, to which both the clients and me reacted in a rather spirited manner.
What do you mean by spirited?
I was outraged. I couldn't believe it. In my career, I'd never seen anything like it. I had never seen an attorney counsel a client in an effort to get the case settled to commit tax fraud and tell the client to just run the risk on a $39 million settlement and basically tell the client to not report the income and thus subject the client to likely imprisonment for not reporting $39 million. I couldn't believe it. In fact, I told Mr. Stoll, you can't do that. Basically, are you out of your mind? And Mr. Parrish and Mr. Fitzgibbons were equally, they recoiled. They couldn't believe it. You haven't met Mr. Parrish or Fitzgibbons, but had you met them, you would understand that that suggestion to these two gentlemen, you could expect no other reaction.
I've been trying to meet him, but so far I've not been lucky enough to do so. Anyway, with respect to this conversation, did Mr. Stoll say he does not give tax advice?
I don't recall him saying those exact words, no.
And didn't he provide the name of a CPA and a tax attorney to Mr. Parrish, Mr. Fitzgibbons, so they could contact them in order to determine how to deal with the tax issues?
I think he did that, but he also advised them to run the audit risk. So whether he advised them to contact other people has nothing to do with the fact that you have a member of the State Bar of California advising clients not to report $39 million worth of income on their tax returns and to, quote, run the audit risk like all of my clients have done.
Was he being facetious or joking about that?
Absolutely not. There's no question about it.
Okay. And did your clients go ahead and commit tax fraud?
Objection. Attorney-client privilege instruction not to answer. It also calls for speculation, likely on behalf of this witness.
That's certainly sustained.
It was worth a shot, wasn't it?
Yeah.
And so where did this advice from Mr. Stoll come into play with respect to the settlement of the case? Was it after an amount had been reached? Was it before an amount had been reached for settlement?
I don't understand the question.
Okay, well, had you already agreed to settle the case for $39 million?
Legal
When-
conclusion. I'm sorry, I thought you
No
were
problem.
finished.
When, I speak slowly sometimes, when this Mr. Stoll allegedly provided this tax advice, or was it before that number had been reached?
Same objection.
I don't recall.
And at the resolution, the settlement of the case for $39 million, what was the atmosphere in the mediation room?
Vague, but you can answer if you understand.
I would say the atmosphere throughout the day was tense.
Was the clients happy to get $39 million?
I think that the clients had mixed emotions about settling the case.
They weren't jumping up and down, they weren't shaking hands, they weren't smiling.
No. They especially weren't smiling after they heard what Mr. Stoll advised them to do.
So now are you understanding that the $39 million number was reached prior to this alleged tax advice by Mr. Stoll?
No, I stand by my prior answer. I don't recall if it was before or after.
Did you and Mr. Parrish hug each other and jump up or down when you got the $39 million settlement?
I don't understand the question.
Well, it's real simple. When they agreed to $39 million, did you and Mr. Parrish grab each other, jump up and down, and hug each other?
At the mediation?
Yes.
Not that I can recall.
Okay. I'll show you another document which will mark as Exhibit 19. It's a settlement term sheet for mutual release and settlement agreement. There you go.
Oh, thank you. Sorry.
You familiar with this document, correct?
Yes, sir.
Was this document prepared at the mediation?
I don't recall.
You reviewed this document before having your clients sign it, is that correct?
Yes, sir.
Were you present when the client signed this document?
I think I was.
And you recognize the signatures of Mr. Parrish and Mr. Fitzgibbons on this document?
Yes, sir.
Were you present when Mr. Davis signed, Mr. Lewis signed, Mr. Fitzhenry signed?
No.
It was all done on the same day, is that correct?
I don't recall. I mean, the dates are all the same.
And did you have an understanding that this was a final settlement of the Fleur matter?
No.
Objection calls for legal conclusion.
No.
Did you understand that this settlement was a valid, binding, and enforceable agreement between the parties according to CCP section 664.6?
Legal conclusion.
I don't recall what my understanding was at that time. I can see what it says in the document here. But in my view, settlements are not final until the money is received and the case is dismissed, in my experience.
Yeah, and the Superior Court of Orange County has a disagreement with you on that, don't they?
I'm not going to answer that question. That's argumentative. I don't know. I don't know what the Orange County Superior Court's position is. I've seen many cases or many attempts to enforce settlement agreements, some of which have been upheld, some of which haven't been upheld. It's a pig in a poke in my view. I don't count a case as being settled until all of the money is paid and the case and all the claims are dismissed.
Well, you've made several motions in law and motion on that exact issue, which the court has rejected, hasn't it?
I don't believe that's accurate, sir, but I'm not here to argue with you what's happened during the case.
Okay. And so in your mind, that the resolution that is set forth on Exhibit 19 was not a final binding resolution of the Fleur case. Is that correct?
Legal conclusion asked and answered.
I think I've already stated my position on this. I'll incorporate my prior answer, and I'll also state that, as I recall, that this was that this document or the settlement was contingent at a minimum on, well, yeah, it's right here, term 5. It was conditioned upon approval by the board of directors of FLIR Systems. So it was not a final settlement because there was a condition precedent that had to happen, namely board approval by FLIR, which was a publicly traded company. And as I recall, $39 million was material to their financial statements as of that date.
Let me show you another document which will mark as Exhibit 20. It's a settlement agreement in mutual release. You're familiar with Exhibit 20, is that correct?
Yes, sir.
You read this document prior to Mr. Fitzgibbons and Mr. Parrish signing it?
Yes, sir.
And you advised your client to sign this document, is that correct?
Objection. Attorney-client privilege. Word product. Instruct the witness not to answer.
I'm going to follow the instruction.
And the settlement agreement, which is dated May 17th, 2011, was a final binding settlement with respect to the Fleur action, is that correct?
Objection calls for a legal conclusion as phrased.
Again, I'll revert back to my prior answer. As far as I'm concerned, a settlement is not final until all the money is paid and the underlying matter has been dismissed as to all defendants, or at least as to the defendants that are settling. That's what I've always lived by. That's what I expect to continue to live by.
The condition for approval by Fleur's Board of Directors is not a part of Exhibit 20, correct?
I don't know. It's been a while since I looked at this document. Give me a moment and I'll look at it.
You know.
Just for the record, the document speaks for itself.
Yeah, what was it that Mr. Frank said yesterday, that he's listening to it but he can't hear anything?
If you're going to use that, you need to attribute it to him in the future.
I did.
I know.
But I'll never use that.
I have quickly leafed through the document. I don't see it in here. If you represent it's not in here, I don't have any reason to doubt your representation.
And so from your perspective, that until the money was paid, there was not a binding and enforceable settlement of the Fleur matter, is that correct?
No, that's not what I said. There's two conditions in my view at a minimum. The money has to be paid and the matter's got to be dismissed.
Okay, well, let's just get right to that then. Show you Exhibit 21. Ask if you take a look at it. I believe that is a dismissal with prejudice.
And I'm going to object to this document on two grounds. First of all, it doesn't contain a Bates stamp number. First, it doesn't contain a Bates stamp number. Second, I will represent as an officer of the court that a version of this document was produced by Meghann Avenatti with a Bates stamp number containing the file stamp on the document, which is not on this document.
Okay.
And that the document was not filed on the date that it was signed by Mr. Avenatti. With that, you can inquire.
Thank you. You familiar with this document, sir?
Yes, sir.
And this is your signature,
Yes, sir.
and this is dated May 22nd, 2011, is that correct?
It was dated that date to be held in escrow until after the money was paid, and it was ultimately filed sometime thereafter. I don't have that date in front of me, but there's a file stamp copy that has that date on it.
That was in June of 2011, is that correct?
I don't know. If you have the file stamp copy that we produced, I can answer, or a docket, I'll be happy to answer. I don't recall the exact date that it was filed.
But as of the 22nd, you had agreed to dismiss this case pursuant to the settlement agreement Exhibit 20, correct?
No, I don't agree with that. As of the 22nd of May, I signed this dismissal, which was to be held in escrow pursuant to the settlement agreement and was to be filed after the money was sent, and the filing of this document was the final step required in order to effectuate and finalize the settlement of the lawsuit.
And you sent that Exhibit 21 to defense counsel on or about the May 22nd, isn't that true?
I don't recall when it was sent to defense counsel. But regardless of when it was sent to defense counsel, it was not to be filed until after the money was paid.
The money was paid on the 31st of May, is that correct?
The money was wired to our trust account on May 31st. I think we already established that. That's correct.
What time of day was the money wired to your trust account?
As I sit here today, I don't recall.
Let me go off the record for a short break, and I may be close to getting done.
We're going off the video record. Time's approximately 4:12 p.m. We are back on the video record. Time's approximately 4:25 p.m.
After you filed your complaint for declaratory relief against Mr. Stoll, you received a letter from Mr. Grassini, did you not?
In connection with, strike that. Yes.
Okay. I'm going to show you a document which will mark as Exhibit 22.
Thank you.
You've seen this letter before, correct?
I have.
Okay. And you see the second sentence in paragraph 1, which states the contract provides all three attorneys have a charging lien on the proceeds of the settlement, which somehow made their way into your trust account. Do you see that?
I see the sentence.
Okay. And you understand that Mr. Stoll and his firm were claiming a lien pursuant to the contingency fee agreement, correct?
No,
You did not understand that?
no.
Do you have an understanding as to what a lien is?
Generally, yes.
When you read Exhibit 6, did you have an understanding of what was meant in paragraph 11 regarding the lien?
Do you have a copy of that exhibit, counsel?
Sort of, Exhibit 6.
Paragraph 11 of what?
Exhibit 6?
So you want me to look at Exhibit 6?
I do.
Oh, it's not there. Maybe it's there.
Did you mark that today, counsel, or was that marked yesterday?
No, it's from
Yesterday's.
yesterday, Scott.
I don't know
It's the
that
fee
we-
contract. All right, I have Exhibit 6.
Go to page 4, please.
Yes, sir.
Paragraph 11.
Yes.
And you agreed to this provision when you signed Exhibit 6, correct?
I agreed to the language in paragraph 11. Yes.
And you understood that in the event that there was a fee dispute, that the attorneys would have a lien on the disputed amount of money.
Only collectively, which is what is made clear in this paragraph, because it says client hereby grants attorneys, plural, and if you look at how attorneys is defined in the first paragraph, it says collectively the attorneys, and then it continues on in the next sentence that talks about attorneys S apostrophe, not apostrophe S, and it is consistent within this paragraph. So no, this contract did not provide a singular attorney such as Mr. Stoll or his firm with any lien right on any proceeds. I don't agree with that, nor did we ever agree to it, because the paragraph is rather clear.
So your position is that my client had absolutely no lien rights with respect to any of the money that was supposed to be paid pursuant to the terms of the fee sharing agreement. Is that correct?
Lacks foundation.
No, that's not correct.
And you did not put Mr. S&P's 35% of the attorney's fees into a segregated account. Is that correct?
Lacks foundation.
I'm going
Asked
to
and answered.
I'm going to stand by my prior answer, and also state that S&P was not entitled to 35%, nor did they have an individual lien right. The attorneys collectively had a lien right against proceeds payable to the clients as provided by paragraph 11. At most, S&P had a right to their quantum merit in connection with the case, which we have been seeking an amount for from your client for some 4 years. But for whatever reason, that amount has not been provided. That's my answer.
Okay. And so you did not heed Mr. Grassini's warning with respect to touching the money that's not yours, correct?
I don't agree with that, and I don't agree with anything contained within Exhibit 22 in the body of the letter. Not a single sentence of this document do I agree with.
Did you talk to Mr. Panish about this document after you received it?
Stand by the prior objections with respect to attorney-client privilege and attorney work product, and instruct the witness not to answer.
I'm going to follow the instruction.
Case was over as of June 3rd, 2011, wasn't it?
No,
It was not?
nope,
When was the case over?
still not over. I still have an attorney-client relationship with the clients, as does Mr. Banish. Still ongoing.
That's interesting. I believe you testified you got the $39 million on May 31st, 2011, correct?
Lax foundation.
I believe that's what I testified to, yes.
And that was at about, what, 5 o'clock a.m. in the morning?
No, you asked me what time, and I told you I did not recall then, and I don't recall now.
And in fact, there was about $18 million wired out of your trust account to Mr. Panish's Goldman Sachs account on the 31st of May, correct?
Well,
Prior instructions with respect to privilege. Instruct the witness not to answer based upon his prior testimony as to how that came about, or didn't come about for that matter.
and I'm going to follow that instruction.
And in fact, there was in excess of $5 million wired out of,
I'm sorry, Ms.
$5 million wired out of your trust account to Mr. Fitzgibbon's Goldman Sachs account on May 31st, 2011, correct?
Same objection, same instruction.
I'm going to follow the advice of counsel.
And tell me how much Meghann Avenatti was paid for its attorney's fees in this matter.
Same objection, same instruction. It's also vague.
I'm going to follow the advice of counsel and refuse to answer the question.
Out of the $15.6 million that was attributed to attorney's fees pursuant to the client contingency fee agreement, how much of that $15.6 million was paid to your law firm?
Same objection, same obstruction. Question also lacks foundation. And
I'm going to
contains a
follow the
legal
instruction.
conclusion.
I'm going to follow the instruction and also note that this was previously asked.
At this point, I am not going to conclude the deposition because of the outstanding issues we have concerning the questions that the recommendations of the discovery referee were to overrule. They were disregarded by the witness and counsel. They were not answered, and therefore we're not going to conclude this deposition. In addition, there were requests for production of documents to be brought here today pursuant to our Exhibit 8, I believe, which were not produced. So I am not concluding the deposition.
Mr. Sims?
For the record, if there were any additional questions that you may have, other than those to which there was a instruction not to answer, those questions should be asked at this time, and it's our position the witness will not be answering any additional questions that could have been asked today. If there's an order with respect to answering some other questions, we will consider that order and our rights pursuant to any such order. Mr. Baker previously noted, as did you, that objections were served to your document request, and we stand on those objections. I take it you are not passing the witness.
I'm sorry, Mr. Sims.
I take it you are not passing the witness.
I am not, and with respect to additional questions that you urge me to ask, I cannot ask those questions now because I don't have the relevant documents in order to do so.
Your Honor, I am here to complete this deposition. I have a very busy schedule. We have gone to great effort to get this deposition scheduled. To the extent that there is any possible question that can be asked, then we want it asked now. We understand there's an issue relating to some of these questions. Mr. Stoll's deposition was completed yesterday in 7 hours at the request of Mr. Keathley. He said the 7-hour limit applied. I don't know where we are on the limit. I don't think we're over the limit. But I am here and am willing to stay until midnight and beyond, if necessary, to answer any and all questions that Mr. Keathley might ask that are not objectionable. And here I am, and I'm prepared to stay for the duration. I want the record to be clear.
No, again, Your Honor, I don't have the documents.
You don't have to repeat it.
Okay.
Your position was stated clearly, Mr. Keathley.
Thank you.
Mr. Sims, you couldn't have said it any more clearly and certainly more succinctly than Mr. Avenatti said it. He underscores with a big yellow everything that you said. And so your record's clear.
Okay.
So we'll just leave it the way it is.
We're
I
done.
can't order anything
Thank you, Your
at
Honor.
this point.
Thank you
So,
very much.
gentlemen, thank you.
Do you want to put stipulation
We will,
considering this point?
Nope.
Okay.
We sort of delayed that stipulation.
Didn't we have a stipulation?
Hold
Hold
on.
on, let me get off. We're going off the video record. This concludes today's proceedings of Michael Avenatti. The time is approximately 4:37 p.m.